Thank you so much for giving us the opportunity to be here tonight. I think we've got 4 attorneys present and all of us are sort of out, it's like a fish out of water. We're not used to presentations and so, but I mean, we're just here to speak about what we do, what we love, and the law for which we have a passion. Jules has mentioned that we come from DML Law. It's a law firm based in Claremont. And tonight, as I mentioned, we've got 4 attorneys present. My name is Megan, and then we've got Arinda. If you just give a wave over there, Arinda. And then we've got Peter and Tshiamo. Please feel free to have a chat with either of us at any point, or to reach out to us if you want to just open a discussion. On our slide, which I think is the next one. Oh, sorry, should I do this? Wow. There we go. I'm fine with this. Okay. So, our firm, those are our 5 major pillars, and as you can see, nothing there is about art or design or anything. In fact, what we do covers many aspects of what you, the creatives, what you follow, what you do in your career, and many challenges that you face. So, for instance, our litigation department, where I mostly work, we deal with contractual disputes. And contracts can cover any type of commercial arrangement, any type of commercial relationship. And I'm sure everybody in this room has, in some form or another, within your careers, found yourself in some kind of commercial arrangement. And that falls squarely within commercial and corporate litigation. So even though it relates to a creative aspect, it still falls within the bounds of the law. So yes, before I jump in, our details of our firm are there, and each of our attorneys will introduce themselves as we move into the workshop. So, next slide. Right, so in a nutshell, that's what I'm going to cover tonight. As I mentioned, any type of commercial relationship comes down to an agreement. And that falls in the law of obligations, and within the law of obligations, we've got contract law. And we see, especially with engagement with the SALC and with Article Africa, many questions are lodged where, it's asked, this arrangement took place, is this an agreement? I just had this discussion, am I in a contract? Can I conclude a contract in this way, in that way, in that way? In a nutshell, a contract in itself is an art. You can get a contract, a simple 1-pager with 2 paragraphs or 1 sentence, or a 100-pager construction contract. They go from simple to massively complex, and that's why we are here. We help navigate those, complex situations and how to put those together and how to take them apart. So, from the beginning, I'd like to stress what the importance of contracting legally, and making sure that you put pen to paper when it comes to what your intention is. In different industries across the world, you'll find in some left-brain industries, people are very serious about putting things into writing, making sure it's clear, and then in the right-brain industry, it's different. We rely more on our relationships, we rely more on our values and motives, but somewhere or another that goes south, and I can testify that when my phone rings with a client, it's not for good news. Usually if my phone rings on a Saturday, it's not to say happy birthday, it's something has gone wrong, and that's essentially what we do. We are professional problem solvers, and contracts can become a big problem. So today we are really just covering the building blocks. I was discussing with one of my colleagues, I can't recall, I think contract law is a year module, Afrikaans. It's a year module. It's extremely complex. It is so dense. But it all starts with this. And it doesn't matter if you've got a one-pager, a verbal agreement, an agreement concluded over WhatsApp, or a massive construction agreement, or a long-term agreement with a gallery. It doesn't matter. All of that comes down to the basics of what we're going to cover today. So some of it might feel like, well, this is common sense, of course, but we deal on the daily with situations where key elements are missing and someone suffers at the end of it. So I think as an artist or a creative, it's so important to make sure that your relationships, your work, your subject matter, whatever you deal with, whatever you share, is protected by the contract that you enter. And that does not mean you have a 50-page massive document signed in front of the police. It just means there's clarity. We know what we have to do, when, how, and in what manner. So I cannot stress enough how important that is. If, of course, things go south, and I'm sure we'll have a discussion at a later stage when you need help, because, yes, it can, unfortunately, not always go our way. So, when does a contract actually exist? And the concept of a contract is an agreement is reached between two or more parties with the intention of creating a legal obligation. So we have to unpack that. The most important aspect of a contract is the nucleus, which is agreement. We have to be in agreement about what we want, what we intend with this, how long should it last, what would dissolve it, what takes it apart. And as I discuss these very simple, mundane concepts, put yourself in a situation. I'm a photographer, I'm being hired to deliver my services at an event. Okay, what should I do? How should I do it? How long do I have? You know, what is expected of me? When you look at your contract, does that tell you exactly what you need to know? So an agreement is either reached as a whole, but it should also be agreed on small specific things. So, okay, photographer, I'm going to deliver services at an event, but there should also be an agreement on what am I being paid for? How long do I have to develop my photos? In what format should I deliver it? To who should I deliver it? If they don't pay me, can I keep my photos? So, big picture, small picture as well. Then it should be noted that an agreement can be reached either through words or through conduct. So if I agree to shoot at Julia's wedding, we agree on the basics, and then that rolls into, okay, now I'm shooting for ASA and I'm shooting for every workshop that follows, and with each instance I would be paid afterwards. But it was never put in writing that I get paid afterwards, but repetitively I got paid after the event. At the 50th event, I can't insist on upfront payment, because through our actions and our conduct, we've agreed that you get paid after. So contract law can be very clear and expressive, but also a bit airy-fairy. But in the end, certainty is what we aim for. So you've got your concept of what a contract is, what it means to reach an agreement, which is essentially the meeting of two minds. And the content of a contract is obviously terms, obligations, timelines, we've covered that. Now the next aspect of when a contract exists is to think of when it is formed. Because many questions we get is, I said this to this person and he responded, are we now in a contract? So this comes down to a theory we call the information theory. You have to consider when an offer is made, when that offer is accepted, but accepting an offer is not enough. You have to communicate your acceptance to the other party. And only once the offerer has received that communication, then the contract is formed. So think of a situation where you're forming a contract over WhatsApp. Offer is made, and when you say, great, happy, when that person receives that message, then that contract is formed. It's an old theory that takes into account when correspondence was only exchanged by letters, but it still applies today. So when you've expressed to someone that you're happy, agreed, let's go ahead, contract is done, you're in there. So the second aspect that we need to think about is, when is a contract valid? So we can all conclude contracts as and when we want to for whatever subject matter, but it doesn't mean that it's enforceable and binding. So very briefly, some of the major things that you need to think about is, does the person have capacity to contract? Is he or she a minor? And there are interesting instances where a person is inebriated or drugged, they don't have capacity to contract. So when you're having a time in a pub and you're striking a deal with someone for very nice artwork or something, but it is, it's a Friday night in Cape Town, it doesn't necessarily mean that your contract is enforceable. Arguable, especially if you've been given too many drinks against your will, and that will mean you've been forced into a contract. So the next aspect is that your performance must be possible. To contract, to create a massively complex artwork within 24 hours is impossible to my mind. I'm not an artist, but a simple example. If it's not possible to perform by the timelines and the deadlines given, it's arguable that your contract is not enforceable. The third aspect is that the purpose of your contract must be lawful. Contracting for a commissioned piece of work made only from stolen items. Not going to go far with that contract, you're probably going to end up in jail. And then lastly, formalities. So formalities is a key aspect in that many people aren't sure whether, if pen is not applied to paper, if agreement actually exists. And as I've said, it can be, a contract or agreement can be reached in a very informal basis. It is only when it was a term between us that a certain formality must be met before it is enforceable, that the contract is unenforceable up until that point. So an example is, I meet Tshiamo next to the street. He's busy performing an art. He's maybe making a beautiful graffiti illustration against the wall. And I say, I like this. I want you to come and spray paint my entire house. It's beautiful, and we are discussing, what would it cost, etc., etc., etc. And then I say, okay, but we aren't going ahead with this. I'll draw up an agreement and then we sign it. Tshiamo can't go home and say that he's just struck the deal of his dreams. He's going to spray paint my entire house and then pitch this the next day, expecting to be paid for spray painting my house. I said that we need to put it in writing and sign. And in that case only, it will remain invalid until you've actually got a written thing signed by the party. So that's an important thing to keep in mind if you want to formalize your agreements going forward. And the importance of formalizing them will definitely help down the line. So I haven't worked with cards since I think 10 years ago, so it's actually quite nostalgic. So I think, so that covers when a contract is valid. When is a contract invalid? So apart from not meeting those things, contracting with a minor or contracting for something that's impossible, you can always get out of an agreement if there was a mistake. So we are contracting for this commissioned work of art. I think, to my mind, it looks like this. This person thinks it looks like that. And we conclude an agreement, but essentially what was missing? A mutual agreement between the states of our minds. We've mistaken both, or one person can also be mistaken as to what the subject matter is and what the purpose is for with which we contract. The second aspect is misrepresentation. When you, say for instance, you're an artist and you want to get your work out there. You want some good exposure, you want to build your social media presence, and you get the services of someone who says that they are into PR and they have years of experience and they know exactly how the Instagram algorithm works and all these types of promises, only to find out later that it was all a misrepresentation. That's usually either it's fraudulent, it's negligent, or it can also be innocent. You can misrepresent that you can do something and realize that actually you can't. So misrepresentation is a way of getting out of it. And then, of course, being forced to contract. You can never be forced to contract or to accept certain terms if you don't want to. And then, when is the contract breached? So you've got valid agreement in place, everybody knows what they are supposed to do, very clear, no doubt. Contract can be breached in three separate occasions. When you are supposed to perform by a certain time and you don't. So, classic example is just late payment. I've sold you a piece of work, and you were meant to pay me within 48 hours, and you missed that deadline. When you miss that deadline, you've materially breached something that is very important, which is your receipt of your remuneration. So, timing of performance. And this is something to look specifically for in your agreements. Make sure that you always know by what time you should do something. It's very tricky to work with a situation where someone misbehaves and doesn't do what they are supposed to do, but there's no time for performance. Then you fall back on old concepts like you have to act reasonable. And I was dealing with a situation today where a client is in the process of acquiring a property and working with a designer / architect who is doing the whole design of the house. You know, she's drawn up the graphic or the drawings. You know, it's been going wonderfully up until a point where something went wrong, but there is no signed agreement in place. There's only some WhatsApp correspondence exchanges. You're dealing with the transfer of a property, you're dealing with builders and contractors, then you've got the architect and the designer who's acting as the project manager. Those are all supposed to be separate agreements with separate terms, and it's just a mishmash, and there's no clarity on where what went wrong and why. So you fall back on things like reasonableness. It gets very difficult. So when you fail to do something timeously is the first instance, and the second instance is when your performance falls foul of what you are supposed to do. So if I contract someone for my wedding to take 5,000 pictures, but on the wedding they only take 500 pictures, that's malperformance. You haven't delivered what you were meant to deliver. So also be sure, and I know it could get tricky if your subject matter is a form of art. You know, I get that it's not always exactly definable, but at least your agreement should be then allow for flexibility in that situation. If it's a term of your agreement that I will use my creativity and my own intuition, put it in there. There's nothing that the person can say against you if they receive something from you and they aren't happy. You know, you are protected if you just make sure that your intention is recorded. And then the last instance is anticipatory breach, when you express an intention not to carry out your agreement. So we're all fine and well. I know that I'm due to deliver my commissioned work of art in a month and 6 days, and today I decide I'm not going to do that, and I communicate that to the other party in the agreement, and I just say, I'm not going to deliver the work of art. That's anticipatory breach. You haven't yet breached the contract because the due date is not there yet, but you've expressed that you will. And in that case, you've also got rights and remedies to take an action now. You don't have to sit back and wait for a month until it actually occurs. So I've sort of segued into the consequences of breaches of contract. When something goes wrong and someone does something against you which is not as agreed, you've got two options. You can either enforce that agreement and say, you will act in accordance with what we've agreed, and if you've suffered any damages or harm in the situation where a person did not perform in terms of the agreement, you can take steps to recover those damages. Or you can cancel the agreement. So if I communicate that I won't be delivering my work of art by then, I can address them to say that you are contractually bound to do so. I'm meant to deliver that work of art at an exhibition which people have paid me to come for, and if I don't have the work of art, I'm going to lose out on the exhibition, and I will have to sue you for what I've lost. So contract law can be very black and white, but the importance of making sure that the boundaries are set, that should always be top of mind. We've dealt with very interesting matters, with interesting arrangements that have gone completely south because there wasn't clarity or it wasn't put down in writing. Some of it was in a WhatsApp message, some of it was on email, and that's fine. If we can put those pieces together and say, this was the agreement, that's completely fine. But just make sure that you always know what is expected of you and what is expected of the other party. And as a sort of a last note, if you are agreeing to contract with someone, or if you are approached with a document, or if someone makes some kind of proposal to you, apply sort of like an Armageddon mindset. Think of, what is the worst case scenario? What could happen here? How can this go south, and am I protected? A consignment agreement. If I'm the art owner or I'm the consignor, how am I sure that when the consignee, I'm hoping I'm not mixing the parties up here, the consignee transports my artwork from point A to B? What happens if that person gets into a car crash? What happens if that person just drives off with my art? Am I going to be protected? So in the common law and in our back, the foundations of our law, yes, but it's going to be a fight to enforce it. Just make sure that your interests are always protected, and that's what Peter and Arinda are going to elaborate on specific pieces which really impact you in your industry, which they will obviously explain, but at the end of the day, especially the topics that Arinda will cover, make sure that that is in your agreement. Or at the very least, just make sure that's recorded somehow, somewhere. And just a quick note, a verbal contract, it's enforceable. We get a lot of questions about, we just had this verbal discussion and, is that an enforceable contract? And that is the case. So they take on different shapes and forms, and it's always interesting to see, every situation is different. Every person breaches a contract in a different way. But when it's clear from the beginning what is expected from who, for how long, for what price, you should be completely fine. I think that covers what I would have liked to share with you tonight. Many aspects of what I've discussed, it's a workshop in itself. It can get so tricky. So I think as a last note, always make sure that you contract with your eyes open. Fairly recently, there was an article in the news about a music artist who she got caught up in an agreement which just automatically renews for 3 years on end, and she never received a copy of the contract. She never really took note of the term itself, and it just turns into a massive legal battle. And that's of course a very unfair term in the agreement, but it can be if you're in a situation where the bargaining power is not equal, you can expect that there might be a few loopholes in there. So always contract with your eyes open and be sure that you know exactly what's been put in the print. And on that note, I'm going to give over to Peter. He's going to take you guys into labour law.